Good morning, class. Today I'd want us to proceed from where we left. Initially, we talked about we left at the composition and the schemes of arrangement, where now the bankrupt has been given some time to negotiate with the creditors and see if they can avoid adjudication through coming into a scheme of arrangement on how to clear the debt or making a promise to pay. And he said at that point, they should show the capacity to pay by providing a scheme of arrangement where they can convince the creditors that they'll be able to clear 25 shillings of every 100 held. And we saw the consequences, and we say that they are dire. They can easily lock you out even to the simplest formation, like a school committee or a road board. We went ahead and checked at the annulment of the order, and today I want us to look at the discharge, or where the order is. I want to share the screen. Where the order is terminated, and that's what we are calling the discharge. And an application can be made anytime after a decision has been reached, but this cannot happen until the conclusion of the public examination, where the debtor or the bankrupt, the person purported to be bankrupt, will be given a hearing, and all the manner of questions will be asked to try and show cause that they are unable to meet their obligations before they are declared bankrupt. So in that case, they'll either be adjudicated or adjudged as bankrupt, or they can go ahead and apply for a discharge. And this is what we are saying cannot happen until the public examination has been had, assuming it has been had. So the notice of hearing must be given on the Kenyan Gazette. And the reason why we are doing this, we want to communicate so that we don't want in future any of the creditors to say that I didn't get the information in the right time. That's why we are doing a broadcast. That's why we are doing a print in the Kenyan Gazette. So this notice will be given to every creditor, and the OR must report to the court on the bankrupt's conduct. Remember, the OR is the person who's been given the mandate to articulate the issues of the bankrupt in this duration, or to see over the entire process. So they will report on how all the conduct of the bankrupt, and the bankrupt will be entitled to a copy of the report, just in case the information that is given is misleading. A minute. Yeah, I was trying to fetch my earphones. I've realized you might be losing me on your end. Well, I'm back. So I was saying that the application of discharge must come after the public examination. And this must make sure or this must be done after communicating to all the creditors on a Kenyan Gazette notice. So the official receiver will come with a report on how he's seen the bankrupt behave and whether the issues pertains to adjudication or as reported by the creditors are indeed true, that this person is bankrupt. So the court may grant an absolute or immediate discharge depending on the report that has been presented by the official receiver. They may also refuse the application for discharge. The court is at liberty based on the information that they'll have gathered or from the report that has been tabled by the OR. Now, in particular, the court may only grant a discharge suspended for a definite period if and only if for every 100 held, the bankrupt is able to pay 50. So 50 over 100 is like 50%. In other words, we are saying, if this person, the bankrupt, is owing people, let's say 1,000, they should show that they have 500 shillings to pay. Yeah, and we are talking of the unsecured liabilities. Remember, the properties of the bankrupt are held by the OR or the special manager who's been appointed by the OR. So at this juncture, the court may grant or they may grant a discharge or they may suspend the application if these conditions are not met. And we are saying that the bankrupt has been convicted, either the bankrupt, if they realize that the bankrupt has been convicted of a bankruptcy offense, or any of the facts that are set in section 29(3) of the Bankruptcy Act shows or have proved the facts against him. That is to say, he holds assets, the unsecured assets, he has less than 50 shillings for every 100 held. To mean he wouldn't be able to meet the obligation. Yeah? Or failing to keep proper books of accounts. There are those people who will have poor bookkeeping. So how do you trace whether they'll be able to pay you if they don't have the records? Whether they are in any business or otherwise. How will you prove? It becomes very hard. Or knowingly trading when insolvent. If this guy has been doing business and they are bankrupt already, chances of continuing to lie are very high. So at this point, the court may suspend the application. All they are gambling, all extravagant living. There are those people, although they are purporting not to have any money, they'll continue living large or flamboyantly. All neglect of business, you can see all frivolous litigation. It's like this guy is joking. He is not seeing that the issues are serious on his case. Or he's been held previously bankrupt, and the composition of the scheme involves or is fraudulent in its nature. If that is the case, then the court may suspend or refuse to grant the discharge. Now, these are the effects of discharge. Suppose it's held. An order of discharge releases the bankrupt from all disabilities that had been imposed on him, except those which had been given for a fixed period after discharge. And of course, this will be provided for as per the provable debts, except debts due to government. You cannot owe the government and they discharge you. You must clear with the taxman, unless the treasury gives you a written consent. So you can imagine going all the way to the CS treasury to try and get the consent for a breach of not meeting the statutory obligation. Then debts incurred by fraud or fraudulent breach of trust, If you are fraudster, this one cannot be discharged. You are criminal or liability under judgment for seduction or under affiliation order. If they realize that you are a con man or you've tried to collude in a divorce action and you had won, then in this case, the discharge will not be effected. So the order does not release the bankrupt from the liability in any case. Yeah? And the revocation can be done at any time by the court. So the court may revoke or vary the order of discharge in the event of the debtor's failure to assist in the required or supplying information. So it's a temporary bailout as we see whether the bankrupt will meet the promises that they have agreed to. If they don't, then this can be revoked at any time. Then we have the trustee in bankruptcy, and this is our business. And he said that a trustee is any person who will act in the interest of the owner. So in this case, the trustee will be working in the capacity or as if they were the creditors. They are the people who are indebted. So the appointment of a trustee is done by the creditors by an ordinary resolution. Remember, the creditors are given the front end. They are the ones who are supposed to identify the person who will be acting in their capacity. Or by the committee of inspection if resolved by the creditors. Now, of course, the committee of inspection, and we'll be seeing this later on, is composed by the creditors who are owed large amounts of money. So it is in that order. And they may be 3 to 5. The requirement is 3 to 5. So those people whom the bankrupt is owing a lot of money are the most aggrieved. So they form the committee. And the court may go ahead and do this if they've not appointed a trustee yet within 4 weeks of the adjudication. So the court has given a ruling that this person is bankrupt, but it takes time. So they'll go ahead within a duration of 4 weeks after the adjudication and appoint a trustee. But this can be, again, the decision can be revoked if the creditors go ahead and produce or select their own trustee. Otherwise, within the 7 days of the rejection of the composition of the scheme, assuming that during the hearing, the public hearing, the bankrupt was able to negotiate a scheme of arrangement. They say that we can settle this out of the court. I have a mechanism, and this is the proof, or this is the evidence that I'll be able to pay these people within the given days. If that day, if the promised day elapses, after 7 days, the creditors can still come again and have the trustee be appointed and go ahead to do the duties that they've been appointed for. So a vacancy will be filled in the same manner. Yeah, so the court will have the power to appoint a trustee within the duration of 3 weeks if there exists no any trustee. But the court objections, the court may object, or the objections may arise if a trustee that was appointed by the creditors or the committee of inspection has the following. 1, the appointment was made in good faith by a majority in value by the creditors voting. 2, the person appointed is not fit to be a trustee. 3, the trustee relationship with the bankrupt or creditor makes it difficult for him to act impartially. And 4, misconduct or failure to render accounts or deal properly with the unclaimed money in previous trusteeship. So if they realize that the appointment was not in good faith, or rather, the person that has been appointed is not fit, and they've had issues with the previous representation, they can go ahead and object. If they don't object, a certificate of appointment will be given. And now the trustee, because he's now the big man here, is given the power to go ahead and declare this in the Kenyan Gazette. So the trustee will go ahead and advertise his appointment. Now he is advertising his appointment. Shall there be anyone who is against it to do the necessary before he goes ahead and deals or performs his duties and obligations? Now we have the committee of inspection that I had said earlier. A committee of inspection will be appointed by the creditors, and this may be done in the first meeting or the subsequent meetings. And the purpose of this committee is to work hand in hand with the trustee. Remember that this person is representing them. So in any case, they have a duty to be briefed or to know what is happening with the process of getting their debts being cleared. So membership, the committee consists of between 3 and 5, I had indicated this, who must be creditors whose proofs have been admitted. So not any other person. There must be a proof that you are indebted, yeah? And normally, this is what I was talking about. The conditions are, these people must be, I'm trying to look at it. I'm saying that these people must be indebted by the person purported to be bankrupt, and the holders of general proxies or powers of attorney. In other words, we are saying that if not the ones, they can go ahead and appoint proxies or people who will represent them. Yeah? And this can be terminated if the trustee resigns. 2, the bankruptcy of the member or arrangement with his creditor. In other words, we are saying if you have a related case, either you are bankrupt or you have an arrangement to pay, then it means that you are already not fit to sit in this office. Then, of course, failure to attend 5 consecutive meetings, it shows that you are not committed. And then removal by creditors. The creditors can say that this person is not representing us. Remember, you are a fiduciary officer of the creditors. So if they deem fit that you are not, or their interests are not catered for by the trustee, they can go ahead and remove him. All vacancies are filled by the creditors. They can go ahead and do another or get another person to fill that position without any reference to you. Remember, they are your bosses. Now, meetings must be held at least once in a month by the committee of inspection, and the fiduciary position of the members. A member is not entitled to payment. So it's like you are committing yourself. Even the trustee, in some arrangement, is meant to do a deposit to show at most good faith. But we'll be coming into that. So a member is not entitled to payment. You are not a servant of the committee, or you are not a servant of the team. So you don't command any payment, or you cannot enter in any transaction in relation to the bankrupt estate. Once you've been selected, there are those people who are shrewd, who can take advantage of the power to go ahead and administer the property that has been held by the OR, but it will be not legally feasible. Now, rights and duties of a trustee. Now, they have these powers. 1, to sell and transfer any part of the bankrupt's property. They can do that to pay the debt. Give receipts for money received. Of course, they'll be receiving if the scheme of arrangement was to be paying this money in installments, he'll be the person who will be receiving this money. So in exchange to account, they'll be dispatching receipts. Take all necessary steps to recover debts due to the bankrupt. So to happen including even liquidating some of the assets. Exercise any powers vested in him under the Bankruptcy Act, bar and entail. In other words, we are saying that this person can go ahead and make a decision if it does not suit the people whom he is representing. You can go ahead and bar any decision that might be injuring the person he is representing, or do all necessary or expedient acts in his official name. Now, with permission of the committee of inspection or the court, he may carry on the business of the bankrupt. So if there are any businesses that were being done by the bankrupt, he's the person who will be undertaking the transactions on behalf of the creditors. Remember, this person is working hand in hand with the OR to bring and defend legal proceedings relating to the bankrupt property. So he'll be representing the creditors in all aspects, all matters appertaining to the property that has been held as a security for the debt. Employ a solicitor or an agent to represent them in a court of law. Sell property in consideration of future payment. Of course, they must admit that this payment will be in the interest of the creditors or to clear their debt. Mortgage or pledge any part of the property. They can go ahead and mortgage. And a mortgage is a right or a privilege to use the property for a duration of time and you pay. So it's like they'll be making money out of the property as they wait for the debt to be cleared. Refer disputes to arbitration and compromise claims. So he's acting as if he's the owner. That's the work of the trustee. Distribute property in specie among creditors. And when we are talking of the property in specie, we are talking of the property in the current state, not the equivalent market or the prevailing market value. We are talking of the current state. So you can go ahead and distribute this property as it is to the creditors. Or appoint the bankrupt to manage his property or carry on with his trade for the benefits of the creditors. So if he deems fit that the bankrupt can go on with the business as he solicits the amount to pay the creditors, he'll go ahead and he has the powers, or pay such allowances as he thinks fit to bankrupt for the support of himself and of his family. So you can imagine it's your business, but because you are rendered bankrupt and this has been passed now to the trustee, he's the person who is in charge of even paying you out of your business. And that's why I was saying that being declared bankrupt is not the best. So you try as hard not to be declared by trying to come into a consensus with the creditors through a scheme of arrangement. However, there is a right of indemnity. If the OR or the trustee has seized or disposed of any property in possession of the debtor without notice or claim relating thereto, he is not personally liable to any person having a claim against the property, unless the court is of the opinion that he has been negligent. In other words, we are saying he is acting in the interest of the creditors. So this indemnifies him. He is not held personally liable. So he'll be held liable as a trustee, but not as an individual, unless the court so proves that this person acted out of negligence. That is the only person, that's the only time that this person will be held liable. Are we there? Then you have the remuneration of the trustee. And this is fixed by ordinary resolution of the creditors, by the committee or by the committee of inspection that has been given the powers to administrate. So it takes a form of a commission payable partly on the amount realized by him. So remember, the trustee must show effort to recover this debt, and that's why he's being paid a commission. So it's not a salary. And this is through a resolution by the creditors. So they must sit and agree, if this guy is able to recover this debt, we are going to be paying him a commission of such an amount. So the court may fix the amount at the request of the 1/4 of the number of value of the creditors or of the bankrupt if satisfied that the agreed amount is too large. In any case, if the figure that has been tagged to pay this trustee is so high, of course, the creditors may go ahead and tell the court, no, we don't agree to this amount. So kindly reconsider. So if they meet a quorum of 1/4, that is 1/4, and they refer this matter to the court, the payment could be reviewed. If the trustee receives any other payment, he loses all right to remuneration. Or if we understand that this person is doing an underdealing to get other forms of payment, then even the little that was considered, he might lose. Now, accounts of trustee. The trustee must keep proper books of accounts, which may be inspected by the creditors at any time. He's representing them. So the cash book must be audited by the committee of inspection at least once every 3 months, is quarterly. Another trading account examined by and certified by them at least one in a month. So they should be seeing that the business is continuing. They won't wait until 3 months are over. They need to know whether the business is earning something, is a going concern. So the accounts must be submitted for audit by the OR every 6 months. And when the estate has been fully realized and distributed, a copy of the audited accounts is returned to the official receiver and another file with the court. So in other words, we are saying that proper books of accounting must be held. We must see the transaction in the trading account. We must see the cash book. Cash book, we've said every 3 months. Trading account every 1 month. Of course, after this has been distributed, we expect that audited books will be presented to the official receiver, who is an appointee of the court, and filed with the court to show that this is the current status of the debt. So the trustee must also submit to the OR a progress report at least once in a year. If it will take several years to clear, then we need to have a work in progress report being presented to the official receiver. Now, trustee bank account. The trustee must pay all money received into the bankruptcy estate account at the prescribed bank. If he retains sums exceeding 1,000 shillings for more than 10 days, he is liable to pay 20% per annum interest on the amount. In other words, we are saying the trustee is not allowed to trade with this money. You receive it and you transfer it to the relevant estate account. Are we there? If this is not done and you retain this money, and we realize that the money has been lying in your bank for more than 10 days, you'll pay 20% per annum of the interest, irrespective. So if you are doing this on the 11th day, and remember, being a trustee, we have access to your bank account to ensure that everything is done as agreed, then you will be surcharged this money. So, and you may lose even the rights to remuneration. So you will be paid because you are trying now to be clever. You are not being fiduciary. A fiduciary is a trusted person who will act in the interest of the other person without taking advantage of them. So they may be removed from the office and liable to pay any expenses that they incurred by taking the advantage of the creditors' money. And this, of course, must be certified and the reasons given to the court. So the trustee cannot draw checks on the bankruptcy estate's accounts, and this is for control reasons. Only the official receiver can do so. Remember, the official receiver is a person who is representing the minister. So you can imagine someone who is representing the ministry and he wants the interest of the creditors to be taken to hand. He's been given that mandate to up and including drawing the checks to ensure that everything goes as planned. In the interest of time, because I have a meeting almost immediately, I want to end it there. We're about to complete our syllabus, so there is no reason to worry. I'll be doing, you need an assignment. We need an assignment 2 before CAT 2. I understand we'll be starting our exam sometime mid-December, but this will be communicated officially. So I'll be doing the assignment in the portal. You could kindly go and check. Otherwise, have a good day and continue going through your notes. Thank you and be blessed.